everyone, I am Anne-Marie I. Bravo from BSC 3-1 and I'm here to discuss to you my topic which is the alternative dispute resolution in the Philippines. So before I start, let me share this simple word of God to you. So from Psalms chapter 75 verse 1, we give thanks to you, O God, we give thanks to you. We proclaim how great you are and tell of the wonderful things you have done. So let's proceed to the objectives of my report. So the number one objective of my report is for us to learn and know what is alternative dispute resolution in the Philippines. Next is learn about the different methods of alternative dispute resolution in the Philippines. And lastly is for us to learn about the importance of alternative dispute resolution in the Philippines. So let me proceed to the main topic, which is the alternative dispute resolution. So what is alternative dispute resolution? It refers to the different ways people can resolve disputes without a trial. So basically, ADR system is an alternative method that our government uses in order for us not to resort in court trials, because we all know court trials is very exhaustive, it's very expensive, and may take long time. So for us to achieve a speedy and impartial justice, our government uses ADR system to also declog court dockets, because we all know that our courts are loaded with pending cases, which uh, causes the delay of the dispute resolution. So ADR system is a great tool to use for a faster, cheaper, and less stressful resolution of disputes. So next, what is alternative dispute resolution in the Philippines? So in the Philippines, we have already a law that is providing and governing the rules of the Philippine Alternative Dispute Resolution System. So it is the RA 9285, also known as the Alternative Dispute Resolution Act of 2004. So let's proceed to the different methods of alternative dispute resolution system of the Philippines. So in my report, I will only discuss 6 methods. However, it is not limited to that, because our country have different methods uh, in resolving disputes. So let me first discuss to you what is arbitration. So arbitration, it is a voluntary process of dispute resolution where one or more arbitrators appointed in accordance with the agreement of the party resolve a dispute by rendering an award. So basically, in arbitration, here's what we call the arbitrator. Um, and the role of arbitrator is to hear arguments and evidence from each side or each disputing party. So um, after hearing the arguments and gathering evidence from both parties, um, the arbitrator now have the power to render judgment or an award, and this award is final and binding. So the um, parties must conform to this judgment. So in arbitration, um, the parties have the freedom to decide the governing law, location, and the rules applicable to the process of arbitration. So for us to understand more, let me discuss to you the process of arbitration. So uh, the arbitration may start when the parties commit themselves to signing a submission agreement to arbitrate. So, ang arbitration po ay mag-uumpisa lang kapag po ang both parties ay nag-agree na ang gagamitin nilang method to resolve the dispute is the arbitration. So in the Philippines, we consider 2 different types of arbitration, which is the international arbitration and domestic arbitration. So in general, um, different arbitral institutions can govern will govern the arbitrational proceedings. So when it comes to international arbitration, one of the many institutions that can govern the arbitrational proceeding is the International Chamber of Commerce, or ICC. Sa domestic naman po, one of the institution that can govern the arbitration proceeding is the Philippine Dispute Resolution Center Incorporation, or the PDRCI. So, after the parties choose what institution is best fit for resolving their dispute, they can now proceed on appointing arbitrator or arbitrator tribunal to help them resolve their dispute. So basically, uh, this institution can provide a list of accredited individuals that can be arbitrators. So the parties may choose from that. However, parties have the freedom to choose non-accredited individuals to facilitate their dispute. So after they have appointed their arbitrator, they can now agree on how to settle the dispute. Uh, they can now agree what are the governing laws, when and where the arbitration should be commenced. So after the process of hearing the evidence and arguments, the end result will always lead to the rendering of an award or judgment. And this judgment, as I have said earlier, is binding and enforceable. The disputing parties should conform to the judgment of the arbitrator. So I hope you understand that. So let me proceed to mediation. So basically, mediation is also a voluntary process in which a neutral individual selected by the disputing parties help facilitate communication between the parties. So in mediation, we have what we call the mediator, and the role of mediator here is to help facilitate communication between the parties and to also help them reach a mutually acceptable solution of their dispute. So the sole role of mediator here is to be able to have a peaceful conversation with both parties. So the mediator have no power to decide the case or render a judgment, unlike in arbitration. So let me proceed to conciliation. So conciliation is just like arbitration and mediation, it is also a voluntary, flexible, and confidential process which is interest-based. The parties seek to reach an amicable settlement of their dispute with the assistance of a neutral individual called the conciliator. So, in conciliation, uh, there is a conciliator that will also help facilitate to have a peaceful communication between the disputing parties. However, it is different from mediation because the conciliator can give an advice or option for the resolution of the dispute of the parties. However, it is different from arbitration because the conciliator can only give advice and option to resolve the dispute. The conciliator does not have the power to render an award or judgment that to settle the dispute of the parties. So I hope you understand the differences of these three. So let's proceed to mini trial. So mini trials is a form of alternative dispute resolution where attorneys on both sides present their case exactly as they would in actual trial. So basically, in mini trials, it is like case court trials. However, it is less formal and less expensive. So the primary goal of mini trials is to have parties evaluate the strengths and weaknesses of their case and understand the potential outcome of their argument. So next a method which is the mediation arbitration or med-arb. So basically, it is a combination of two processes in which the parties must go through first mediation, and if the mediator fails to settle the dispute uh, by just having a peaceful communication between the parties, the parties the parties shall then go to arbitration, wherein the arbitrator will have to decide and give judgment to resolve their dispute. So next is the early neutral evaluation. So early neutral evaluation is an informal non-binding means of dispute resolution where the parties agree to resolve preliminary sense checks from an independent third party who's an expert in relevant fields. In early neutral evaluation, the only purpose of this method is to help both parties evaluate their case, to also know what are the strengths and the weaknesses of their cases. So it is up to the parties if they will proceed to court trial. So I hope you understand those six methods of alternative dispute resolution system of our country. So let me proceed to the advantages of alternative dispute resolution system. So basically, ADR system can give us freedom, just like what I have said earlier. ADR system uh, gives the parties to have their freedom or the ability to choose what are the processes that they can choose, what are the governing laws, uh, what is the best suitable rule for the for both parties, and when and where should it be commenced. So next is that ADR system is much faster and cheaper than traditional litigation. So we all know that court trials is very exhaustive, takes long time and expensive. So with ADR, we can now achieve to have a speedy trial and can resolve dispute uh, cheaper and within a short time. So next, it is secured and effective. So basically, we all know that court trials should, shall always be public. However, in ADR system, there will always be privacy for both parties because under the Section 9 of the Republic Act 9285, it is stated that information acquired through mediation shall be privileged and confidential as subject to certain exceptions as provided for Section 11 of the same Act. Additionally, in Section 23 of the same Act, it states that arbitration proceeding together with the record of and evidence and the arbitral award shall be deemed confidential and shall not be disclosed or published provided there are two exceptions in the same section. So let me proceed to the cases where an alternative dispute resolution system can be applied. So it can be applied to civil matters, family matters, labor and employment matters, business and commercial disputes, construction and real estate disputes, environmental and land use disputes, consumer disputes, insurance claims, intellectual property disputes such as patents and yung mga trademarks, the government and administrative cases. Next is the community and neighborhood cases, which is actually the most common because we all know that neighbors have always disputes and ADR can help resolve disputes. Next is online disputes. Let's proceed to the exception in applying the ADR system. So firstly is it ADR system cannot be applied to labor disputes that is covered by PD number 442 or also known as the Labor Code of the Philippines as amended and its implementing rules and regulations. Next is the civil status of person. Next, the validity of marriage, any ground for legal separation, the jurisdiction of courts, as well as the future legitim or yung mga pamana, hindi po pwede gamitin yung ADR, and criminal liability, ang ADR po ay hindi po pwedeng gamitin sa kahit ano pong criminal cases. And lastly, those by which by law cannot be compromised. So that's all. To end my discussion, I will share a simple quote to you, which is the first step in resolving a conflict is solution. We should hear both parties and shall not be biased. We should always render an impartial judgment for both parties. So thank you for listening to my discussion, and I hope you understand. Thank you.